Neathfield, Blackburn, LIAT.
Good morning. I'm sorry that we're sitting just a little late. I hope that Council will not take amiss these prefatory words. We have been greatly enlightened by the very extensive cases that have been submitted by the judgments of the Industrial Court and the Court of Appeal, and we're confident that the case can be presented much more concisely than the time indicted for. Right, indented for, I should say, not indicted for. Yes.
Much obliged for that word of caution, my lord. My name is Douglas Mendez. I appear along with Imran Ali on behalf of the appellant.
Thank you.
And my learned friend, Mr. Ruggles Ferguson, appears with Mr. Septimus Rudd and Miss Amy Bullock on behalf of the respondent.
Thank you very much.
There are two...
Can I just note that down? Amy Bullock?
Amy Bullock.
We've got Ms. Blackburn Steele.
It's Amy Bullock appearing, I'm told.
Thank you. Now, how is that spelled? How is that spelled? Thank you very much. Yes.
Yes, Mr. Mendez.
My lord, briefly, we say that the decision by the Industrial Court that the dismissal of the respondent was unfair was based upon the application of the wrong legal test. And in that regard, we refer to the Labor Code, in particular section C58, subsection 2, which you would find at page 852 of the electronic bundle, which is stated that the test generally for deciding whether or not a dismissal is unfair is whether or not under the circumstances the employer acted unreasonably or reasonably. But, and then it goes on to deal with a situation where the employer is mistaken as to the factual basis of the dismissal. There are a number of cases, of course, in the English jurisdiction which flesh out exactly what the test of reasonableness is, and we have set out the cases there, and I will attempt to deal with them as briefly as possible. The test, of course, is similar in the English jurisdiction, and the Court of Appeal of the Eastern Caribbean has accepted that the test, as has been set out in the House of Lords decision in Polkey against Dayton, is the test to be applied in relation to the Labor Code and the Industrial Court's jurisdiction. The test is an objective one. The question is whether the employer acted reasonably in dismissing the employee. The question is not whether the Industrial Court itself considers that the dismissal is fair or not. In other words, it's irrelevant what the Industrial Court's view of the action taken by the employer is. The question is whether what the employer did fell within a band of reasonable responses to the employee's conduct which a reasonable employer could adopt. And that has been set out in the judgment of Brown Wilkinson J, as he then was in the Iceland.
That's not a matter of controversy, is it?
Not at all, my lord. It is. The authorities also establish that the failure to follow a stipulated procedure or the rules of natural justice will not necessarily render a dismissal unfair, and that too is not controversial. The question in each of those cases is whether the employer could reasonably have concluded that a hearing would make no difference. But the authorities also establish that under no circumstances must the tribunal ask itself whether a hearing would have made a difference. If it asks itself that question, that would be tantamount to the tribunal substituting its own view for that of the employer. And you will see that in the passages from the judgment of Lord Mackay and Polkey against Dayton at electronic pages 1116 over to 1117. And if I can just read briefly at the top of page 1117, just below letter A, it says, that leaves no scope for the tribunal considering whether if the employer had acted differently, he might have dismissed the employee. It is what the employer did that is to be judged, not what he might have done. And then just below letter B, if the employer could reasonably have concluded in the light of the circumstances known to him at the time of the dismissal that consultation or a warning would be utterly useless, he might well act reasonably even if he did not observe the provisions of the code. And then you will see at electronic pages 1119 to 1120, the passages from the judgment of Justice Brown Wilkinson in Silliphant and Powell Dufferin were adopted by Lord Mackay. And in particular, if you look at 1119, at just below letter G, Justice Brown Wilkinson, as he then was said, an industrial tribunal is not bound to hold that any procedural failure by the employer renders a dismissal unfair. It is one of the factors to be weighed by the tribunal in deciding whether or not the dismissal is unfair. And lastly, in the judgment of Lord Bridge, at page 1126, just below letter E, he says, if an employer has failed to take the appropriate procedural steps in any particular case, the one question the industrial tribunal is not permitted to ask in applying the test of reasonableness posed by section 57.3 is the hypothetical question whether it would have made any difference to the outcome if the appropriate procedural steps had been taken.
Yes.
And if I can refer you further, and just very briefly, the decision of Lord Justice Hale, as she then was in Whitebread against Hall, in which she had said that the band of reasonableness test also applies where the allegation is a failure to follow proper procedure. And at electronic bundle page 1163, she says, just above letter F, there are some cases of misconduct so heinous that even a large employer well versed in the best employment practices would be justified in taking the view that no explanation or mitigation would make any difference. But this was not such a case, and as the House of Lords made clear in Polkey against Dayton, the one thing which the tribunal cannot do is to ask itself whether the outcome of a fair procedure would have been the same. We respectfully submit that that is precisely the question which the industrial court asked in this case, a question which was not permitted to ask in applying the test under C58.2. If I can draw your attention to the judgment of the industrial court, electronic bundle, page 164. The heading is just above paragraph 119, whether in the circumstances the employer acted reasonably or unreasonably in dismissing the employee, which is the question to be asked. But in paragraph 119, they interpret the question in this way. In some cases, the absence of a fair procedure may not by itself render dismissal unfair. We have no problem with that sentence. In other words, the adoption of a fair procedure would nevertheless lead to a dismissal which is not unfair. In other cases, a fair procedure could make a significant difference in the outcome. The question at this point is, in which of the two categories does the employer's actions fall? So therefore, they're asking the very question they're not supposed to ask. And then over at page 165 in paragraph 126, the court concludes, at the end of the day, we find in the circumstances, following a fair procedure generally, and providing the employee with the opportunity to be heard in particular, could have made a difference in the employer's deliberation before the dismissal. And then 127, we apply the test. When we apply the test of reasonableness, having carefully taken into account these factors, we consider that the employee was unfairly dismissed. So we say the very question which the court was by the authorities not permitted to ask, they asked and they decided the question on that basis. Accordingly, the appellant has not had a fair opportunity before the industrial court of having its case determined in accordance with section C582 of the Act. On that basis alone, we say that the decision ought to be overturned. In addition, more directly at page 164 of the electronic bundle, paragraph 120, even though the court had already said that if you fail to follow a procedure, it doesn't necessarily mean that the dismissal is unfair. The court said, apart from its failure to discharge its evidential burden, we have the opinion that in any event, the breach of the employer's clear contractual obligation to follow the agreed procedure, reinforcing its commitment to abide by the principles of natural justice, was sufficient by itself to render the dismissal unfair in the circumstances. Therefore, it doesn't appear even that they asked itself the question, well, is it possible in these circumstances that a reasonable employer may have dismissed, may have reasonably thought that a procedure would not make a difference. So the question, we say, of course, if the board agrees that the industrial court did not apply the right test, then the right order would be to send the matter back for the industrial court to apply the law to the facts as were presented to it. We anticipate, however, having regard to the way the learned friend has pitched his case, that they will eventually say to you, well, even if you find that there was an error of law, there has been no substantial miscarriage of justice and therefore dismiss our appeal. We say that because they have spent a lot of time addressing the question whether on the facts before the industrial court, the respondent can be held to be guilty of misconduct.
I think what they're saying is that even if the tribunal had asked itself the question which you say it should have asked itself, it would inevitably have come to the conclusion that the dismissal was unfair.
Yes, I believe that that is what there is. And if I may address that, it could be brought under Section 17.3 of the Industrial Court Act. That is, you'll see that at electronic bundle, page 875, where it says that the Court of Appeal may, in any matter brought on appeal before it, dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred. Page 875. Subsection 3, that would be 17.3. The Court of Appeal may in any matter brought on appeal before it dismiss the appeal if it considers no substantial miscarriage of justice has actually occurred, or it is of opinion that any point raised in the appeal might have been decided in favor of the appellant. So we are anticipating that what they're saying is that even if you apply the correct test, then you would come to the same conclusion, and therefore there's no substantial miscarriage of justice. We respectfully meet that point in two ways. First of all, by pointing to the findings of the court in relation to relation to what the respondent did. And you will see, for example, at page 163 of the electronic bundle at paragraph 111, the court said that at the end of the day, we find that on the evidence disclosed in the transcript and audio recording, subject to the proper administration of the established fair procedure, the employee was guilty of misconduct which was serious enough to potentially justify his dismissal. And then later on, from pages 166 over to 168 of the electronic bundle, when they're addressing the question whether the employee contributed to his dismissal, they criticized the respondent's conduct in fairly harsh terms.
Mr. Mendes, you're asking for the matter to be remitted to the industrial court, what, 8 years after the dismissal?
That's correct.
Would you have a right to be heard if it was remitted? The complication is that because of the quite extraordinary failure on the part of the employer to file a memorandum, the industrial court decided to hear the case, quote, ex parte, unquote. And although you were permitted to cross-examine the employee, it stressed that this was nevertheless ex parte. And so it's a very complicated situation, but what would be your submission as to your locus standi to address the industrial court were any such remission to be directed?
Well, apart from giving directions that, or permitting counsel for the appellant to cross-examine the respondent, they also permitted the appellant to put in written submissions on the question of liability. So they dealt with the question of liability first, and the appellant had the permission of the court to make written submissions or oral submissions, as the case may be. So if the matter is sent back to the industrial court, presumably that would stand. There's no reason to think that it wouldn't stand. So the appellant would be entitled to look at the evidence that is before the court and to make submissions on how the proper legal test is to be applied in the circumstances. Of course, part of the complication, as you mentioned, is whether the industrial court, if it is sent back, would be able to rely on the transcripts and the recordings, and that is the subject of the other part of the appeal. But if it were permitted to refer to the transcripts and the recordings, then the appellant would make submissions on those transcripts and recordings.
But you certainly wouldn't presumably be entitled to put in any evidence.
No, we accept that.
You haven't been, and you presumably consistently wouldn't be, and so you wouldn't be able to put in any evidence about why the decision was taken not to inform the employee of the proposed dismissal.
No, we wouldn't be permitted to do that.
They will.
Because we accept that the employer applied after the trial to reopen the case, and in the judgment delivered in 2017, the industrial court refused that application, and there has been no appeal against that part of the decision. So all we'd be able to do is to address on the evidence that is properly before the court.
Yes.
But the point that I'm making is that having regard to the comments that the industrial court did make about the respondent's conduct, concluding at page 167 over 168 in paragraph 137, as stated above, after careful consideration of the dismissal letter, the transcripts and the audio recordings of the employee's statements, we found that the employee was guilty of misconduct, which was potentially good cause for dismissal. In particular, we are inclined to accept the employer's view as expressed in the dismissal letter that the employee's statements did or were likely to do harm to the professional reputation of and public confidence in the employee's senior management team and its business as a whole. Moreover, we find that the employee's misconduct was more conspicuous and at least more potentially embarrassing and harmful by virtue of his emphasized position as chairman of the pilots' union. The point is that he made comments concerning the safety of the airline. He said that it was worse than it was in previous years, and of course the listening public would wonder what's going on with this airline. Should we travel on it? So it is particularly damaging. My point is that sitting here at this stage, your lordships would not be in a position to deny that there's a real possibility, at the very least, that the industrial court, applying the correct test, may, on the basis of the findings that they have already made, come to the conclusion that for one, what the respondent said is not in dispute, and that they could reasonably take the view that nothing he said would make a difference. And of course, we rely as well on the decision of the dissenter in the industrial court, who himself came to the conclusion that the dismissal was fair. In other words, if you ask the question, did what the appellant do in this case fall within the band of reasonable responses, then it cannot be ignored. I respectfully submit that the dissenter thought that a reasonable employer could behave in this way, and therefore it is quite possible that the entire court, considering the correct question, may also come to that conclusion. But in any event, we go further and say that the question which my learned friends is asking you to decide, that is to say, whether a reasonable tribunal applying the correct test would come to a different decision, whether a reasonable court applying the correct test would come to a different decision. We respectfully submit that that is not a question that can be posed to this board, because an appeal against the opinion of the industrial court as to whether a dismissal is harsh and oppressive or not in accordance with good industrial relations practice is prohibited by Section 10(6) of the Industrial Court Act. If I may take you to that provision, you'll see it at page 871 of the electronic bundle. says that the opinion of the court as to whether an employee has been dismissed in circumstances that are harsh and oppressive or not in accordance with the principles of good industrial relations practice, and any order for compensation or damages, including the assessment thereof, made pursuant to subsection 5, shall not be challenged, appealed against, reviewed, quashed, or called in question in any court on any account whatever. And Section 17 of the Act, at page 874 of the bundle, does provide for a right of appeal against decisions of the industrial court, but it says, subject to this Act, any party to a matter before the court shall be entitled as of a right to appeal to the Court of Appeal on any of the following grounds, but no others. A deals with the question of jurisdiction of the court. B deals with whether the court has exceeded its jurisdiction. C deals with fraud. D deals with that it's erroneous in point of law. And then E deals with some other illegality. Now, but of course, 17.1 is said to be subject to the Act, which means it's subject to Section 10.6, and therefore we have to read them together. Your Lordship's board in the Sundry Workers and Antigua Hotel and Tourist Association case, you will see at electronic bundle page 1145. In that case, your Lordships had to consider whether it could review the industrial court's decision on compensation. And at page 1145, referring to Section 10 of the Act, in particular Section 10.6, the board concluded, just below letter G, it appears to their Lordships that when the industrial court has found that employees have been unfairly dismissed, the necessary implication of such a finding is that the dismissals were in circumstances were not in accordance with good principles of good industrial relations practice. From this, it must follow that no appeal lies against the awards of compensation made by the industrial court in this case. And therefore, we respectfully submit that it follows as well that no appeal lies against the opinion of the court as to whether the dismissal is not in accordance with good industrial relations practice. That is, in fact, is the approach that has been taken by, first of all, the Court of Appeal in this case, because it held that it would not embark upon an assessment of compensation of its own, even though it overturned the industrial court's decision that the respondent was only entitled to 35% of his compensation. They accepted that they had no jurisdiction to enter into that question, and therefore they referred the question of compensation back to the industrial court. And you'll see from their judgment that they accepted the jurisprudence coming out of the Court of Appeal of Trinidad and Tobago. Because the Court of Appeal because in Trinidad and Tobago we have almost identical provisions in our Industrial Relations Act. So you'll see at page 34 of the appellant's reply, electronic bundle number 34 of the reply. It's a different numbering sequence. It's an electronic paragraph. No, it's an electronic bundle numbering at the bottom of the page. 34. 34, yes. You see Section 10.6, the opinion of the court as to whether worker has been dismissed in circumstances, etc., which is identical to the Industrial Court Act of Antigua and Barbuda. As a matter of fact, the Industrial Court Act of Antigua and Barbuda was passed after the Industrial Relations Act in Trinidad and Tobago, and they seem to have adopted a number of the provisions in relation to the jurisdiction of the court are identical. And then the provision dealing with appeals is to be found at page 36 of the bundle. And this is section 18.2, which says, subject to this act, any party to a matter before the court is entitled, etc. And it's in identical words to the corresponding provision of the Industrial Court Act of Antigua and Barbuda. Now, so
this complicated balance between two apparently conflicting subsections that's had to be addressed in Trinidad and indeed in Antigua you refer us to this for what particular purpose? To inhibit us from doing what, Mr. Mendes?
From inhibiting you from doing what Lord Jackson suggested that the court, you might do, which is to ask the question whether, if the industrial court had applied the correct test, whether it would have come to any different result. Presumably, the point being that if you conclude that the result would be the same, then there's no point sending it back to the industrial court. And you apply the proviso, as it were, that there's no miscarriage of justice, and therefore you dismiss the appeal, even though you find that the industrial court did not apply the correct legal test. So I'm saying that that is not a question that you can ask, because the Act itself has reserved the question as to whether a dismissal is unfair to the industrial court and the industrial court alone, as long as it applies the proper legal test, of course. And that is a point that is made by the Court of Appeal of Trinidad and Tobago in the All Trinidad Sugar Union case. And I'll refer you to page 57 of the reply. And this is the judgment of Sir Isaac Hayatali, the Chief Justice. And on pages 57 to 58, he's analyzing the interaction between 10.6 and 18.2. And around the middle of the first paragraph on that page, where the sentence begins, "It follows."
Yes.
He says, "It follows, therefore, that section 10.6 is to be read together with and given effect to as a proviso to 18.2. In my opinion, this conclusion is fortified by the fact that section 10.6 occupies a special place in the earlier part of the Act, and to all appearances has been deliberately inserted there to put it beyond doubt that appeals will not be allowed against the court's opinion in what is manifestly a highly specialized area of industrial relations, namely, whether or not a worker has been dismissed in circumstances that offend against the principles of good industrial relations practice or are otherwise harsh and oppressive. Consequently, if an appellant is unable to rely on any of the statutory grounds of appeal specified in section 8.2, then he is barred from appealing altogether, since the Act prohibits him from relying on any other ground. If, however, he is able to rely on one or other of those statutory grounds, he will nevertheless be barred from appealing if the only ground of appeal on which he relies involves a challenge against an opinion of the court given in pursuance of section 10.6. And then he goes on to say that it might be an unusual provision, but it is I'll read it, but is manifestly a sensible and logical one, since members of the industrial court are normally selected for appointment thereto by reason of their specialized knowledge and experience in industrial relations and related matters. It is only right, therefore, that their opinion, duly formed on a question arising in such a specialized area of human relations, should be final and not subject to review or recall by members of the Court of Appeal, who would normally have no such knowledge or experience. And in a more recent case, that is the Carani 1975 Limited against ATAS, Chief Justice de Labastide, as he then was, Chief Justice Labastide became the president of the Caribbean Court of Justice, at pages 39 to 40, expressed his opinion on the operation of these two sections, 10.6 and 18.2, and you'll see just above letter G, he said, "The wording of 10.6 is very explicit. However, reluctant the court may be to accept that its jurisdiction has been ousted by an act of Parliament, and that it is thereby denied the opportunity of investigating an alleged injustice and correcting it, if found to exist. The intention of Parliament is too clear in this instance to be deflected by any presumption of law or canon of construction. It is clearly the duty of this court to give effect to it. We must not be tempted to do otherwise by pictures painted of the gross injustice which may be perpetrated if we recognize and accept the restriction which Parliament has imposed on our right to interfere. In any case, section 10.6 does not oust any pre-existing jurisdiction of the Court of Appeal. The industrial court is a comparatively recent creature of statute, and so is the right given to appeal from it to the Court of Appeal." And then he goes on to deal, my lords, I don't want to waste your time by reading everything there, but if I could take you over to the following page, at letter C, he says, "A harsh and oppressive dismissal is something which, according to the Act, may be identified only by the industrial court. It does not matter whether the party challenging the decision of the industrial court on this issue claims not merely that the decision was against the weight of evidence, but goes further and claims that no reasonable judge properly directed could have come to the same conclusion having regard to the evidence. In the latter case, the ground of appeal has graduated from a question of fact to a question of law, but it is nonetheless barred by prohibition contained in section 10.6. This is not to say the decision of the industrial court as to whether dismissal is harsh and oppressive is so sacrosanct that it can never be challenged on any ground whatever. If, for instance, there has been some procedural irregularity which involves a breach of natural justice, then clearly an appeal would lie to the Court of Appeal, notwithstanding 10.6. In such a case, excuse me, it will be process by which the industrial court reaches opinion, and not the opinion itself that was challenged. So that according to the way in which the Court of Appeal of Trinidad and Tobago has interpreted the provision, not even an argument that no reasonable tribunal properly applying the law would come to that conclusion, even though that would be a point of law, that is not an argument that can be raised against an opinion of the industrial court.
I'm struggling slightly. I mean, the statutory provision and the judicial passages to which you've drawn our attention
Yes.
are by and large restrictions on appellants.
Yes.
You can't challenge the finding of this, that, or the other.
Yes.
But, of course, here you are the appellant, and you are challenging the finding of unfair dismissal.
Yes.
Even so, I think you've demonstrated to us, subject to what counsel may say on the other side, that the effect of section 10.6 and the comments on section 10.6 in the
Yes.
authorities, the effect is that section 137 of the industrial impregnable, that is the decision that the employee's misconduct is potentially a good cause for dismissal.
Yes.
Leaving aside the processes.
Yes.
But the industrial court, on your analysis, has never asked itself the question which you say it ought to have asked.
Correct.
itself. And so, if we were to form our own view as to how the industrial court would have answered that question, I'm not quite sure that I see anything in the authorities that says we would be going against section 10.6. We wouldn't be rejecting anything which the industrial court said. We would merely be addressing something which the industrial court, on your analysis, has not considered.
Yes.
So the authorities don't quite get you home on this point, do they?
Well, I think that they do, and if I may explain why. First of all, what is protected under Section 6 is the opinion of the court on the question of whether the dismissal is fair or unfair. But that opinion can only be expressed in accordance with the test that is laid down in the Labor Code, because the Labor Code itself says in Section C58(2) that the test of fairness is reasonableness. So we say that we can come to this court and ask the court to review the decision, the opinion of the industrial court on the ground that it applied the wrong legal test. We come under Section 17(1), where it says that you can raise a point of law. But if the court applied, let's assume that in this case the court applied the correct legal test, and there was an appeal against that decision, then it will be met by an argument. You cannot appeal against it because they applied the correct test. And the learning that I've referred you to indicates, and this is what we rely on, that the intention of the legislature obviously is that it is the industrial court alone that has the power and authority to determine whether a dismissal is unfair or not. And
when it applies the right legal test.
Once it applies the correct legal test. Once it applies the correct legal
Right,
test.
Let's move on to the premise that you advanced, that they didn't apply the correct legal test.
Well,
What then is the scope of the
Yes.
Court of Appeal?
Yes. Yes, and the point is that if you now embark upon an exercise of seeking to determine whether applying the correct legal test, the dismissal is unfair or not, you would be doing exactly what the legislature has said only the industrial court can do.
Following on from Sir Rupert's and Lord Care's observations, Can you address us, please, now on Section 17.3 of the Antigua Act,
Yes.
which we find at 875 in the electronic bundle? Subsection 3. The Court of Appeal may, in any matter brought on appeal before it, dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred, although it's of the opinion that any point raised in the appeal might have been decided in favour of the appellant.
Yes.
Can I ask you to address us on why we should not read that subsection as follows? The Judicial Committee of the Privy Council may, in any matter brought on appeal before it, dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred, although it is of the opinion that any point raised by Mr. Mendes might have been decided in favour of his client.
Well, I've addressed that in part by saying that on the facts as found by the Industrial Court, it would not be possible for the court to say, this board to say that the Industrial Court would not come to a different conclusion if it applied the correct test, having regard to his findings made, the findings made in relation to his conduct. So that's one argument I've made already. But the second argument that I am making is that Section 17.3 must be read in conjunction with Section 10.6 and how the provisions operate, which essentially requires this board, the Court of Appeal and this board, to defer to decisions of the Industrial Court.
Well, I'm sorry to interrupt, but does that mean that you submit that Section 17, subsection 3, cannot operate in circumstances where the Industrial Court has applied the wrong test?
On a decision concerning dismissal, where it has expressed an opinion under Section 10.6.
Well, that
in relation
seems
to
me read in quite a bit to Section 17, subsection 3, because the injunction there is that where the Court of Appeal considers that no substantial miscarriage of justice has actually occurred. And therefore, it seems to me that on a plain reading of that provision, if a Court of Appeal, or indeed the board, were to conclude that if the Industrial Tribunal had applied the correct test, there's only one conclusion that it could have reached. And therefore, notwithstanding the misapplication of the test, no substantial injustice has occurred.
I appreciate the point, my Lord. My response to that is that reading the Act purposely, as obviously you must, the intention of Parliament is that that question as to whether, when you apply the correct test, the dismissal is held to be fair or unfair, as the case may be, is a question that is reserved for the Industrial Court to answer. The point being that it may very well be...
That is right. It represents a very significant circumscription on the powers available to a Court of Appeal under Section 17, subsection 3.
In relation to these types of disputes, yes.
I see.
Could you just help me before we leave the Caroni and Atas case? At page 40 of your reply, the court is saying at around D, the ground of appeal has graduated from a question of fact to a question of law, but it is nonetheless barred by the prohibition contained in Section 10.6.
Yes.
And yet you say we can appeal against the unfair dismissal because it's a question of law.
Because the opinion that is referred to in Section 10.6 is an opinion that must be exercised in accordance with what the Labour Code says, which is that the test of a fair dismissal is reasonableness.
But this looks as if it's saying no matter if it's a question of law, it's sacrosanct.
Well, the Industrial Relations Act in Trinidad and Tobago is operating not in the context of a labor code such as in Antigua, so that the question whether the dismissal is harsh and oppressive or not in accordance with good industrial relations practice is not otherwise controlled by any other legislation. It is
So
a test.
It's not quite the same, Trinidad and Tobago.
It's not quite the same because you have the labor code. You have the labor code in Antigua stipulating that the test of fairness is reasonableness, and therefore we say that the opinion that is referred to in 10.6 is an opinion that is in accordance with the test set out in section C58. But once you're applying that test, the submission is there can be no appeal against the decision. And if there can be no appeal against the decision, then this board ought not to, in effect, usurp the jurisdiction of the industrial court by expressing its own opinion as to how the correct test would be applied in the circumstances. Because it may very well be that the matter is sent back to the industrial court and they come to a different conclusion that the your lordships and your ladyships are minded to come to on the facts as presented before you.
Right, well,
Much obliged.
let's move on.
So those are my submissions on that point. Just to conclude, we are asking that you send the matter back to the industrial court so that they can determine whether the dismissal was unfair on applying the correct test.
Mr. Mendes, before you leave point one and go on to point two in the appeal, I'm afraid, and it's entirely my fault, we did look at paragraph 126 of the industrial court decision, which is at 165 to 166.
Yes.
But I didn't fully understand why you say that that is not a reasonable way of approaching the correct inquiry. Paragraph 126 of the majority decision, 165, electronic.
Yes.
At the end of the day, we find that in the circumstances, following a fair procedure generally, providing the employee with the opportunity to be heard in particular, could have made a difference in the employer's deliberations before the dismissal. Why is that the wrong approach?
It is a wrong approach because it's not asking the question, first of all, what is the band of reasonable responses to the conduct of the respondent in this case, and whether the appellant's conduct fell within that band. It is not approaching the question on an objective basis. It is the industrial court itself asking the question, would it have made a difference, and coming to its own conclusion as to whether it's made a difference. And directly speaking.
Could have made a difference.
Yes.
Not would have made a difference, could have made a difference.
Yes.
So they're looking at a band, and they're saying if the opportunity had been given to the employee, it is possible that they would have decided not to dismiss. Surely that's the correct way of looking at it.
Well, it is the industrial court itself asking itself that question, and not asking itself, well, what are the range of possible responses of reasonable employers? It is itself saying, we are concluding that it could have made a difference. And a reasonable employer might very well come to the conclusion that it could make a difference, and therefore I will have a hearing. But they have not considered the possibility that another reasonable employer might take a different view. So it is the failure to ask itself that question, to explore the possibility of what other reasonable employers might do, that caused it to run afoul of the application of the test.
Thank you.
Much obliged to you, madam. The second part of the case deals with the industrial court's finding that the compensation to which the respondent was entitled should be reduced by 65%. And that was based upon its assessment of the conduct of the respondent, and I will not take you back through that again. I've just referred you to the relevant paragraphs. But the respondent had appealed against that decision on the basis that the industrial court had asked for and admitted into evidence the transcripts of what he said on the radio and the audio recordings of what he said, and taking those into account, and they did not act fairly in doing so. He said that in the Court of Appeal. He also said that they exercised the discretion to admit them wrongly, but the Court of Appeal didn't address that part of the case. They only dealt with the question of fairness. My learned friend now seeks before your lordships and your ladyship to readdress the question of whether the discretion was exercised properly or not, but that was not one of the agreed issues that was brought before the board, but I leave it at that for the moment. The Court of Appeal found, first of all, that the Industrial Court could not admit the transcripts and the audio recordings in evidence after the trial had been concluded. In doing so, they did not actually look at the provisions of the Industrial Court Act that had been referred to them, dealing with the court's powers. And we say, and I've said that out in the written submissions, that there is no limitation on the court's power to call for evidence of its own motion. And I will refer you very briefly to the provisions of the Industrial Court Act, electronic bundle, page 868, section 8.2 of the Act. For the purpose of dealing with any matter before it, the court may of its own motion summon any person who in the opinion of the court is able to give such information as it considers necessary, and may in addition, and without prejudice to the foregoing, and it deals with requiring tax information and so on. So it can have its own motion, seek information from anyone. And then page 869, section 9.1, it says, in the hearing and determination of any matter before it, the court may act without regard to the technicalities and legal form and shall not be bound to follow the rules of evidence stipulated in the Evidence Act, but the court may inform itself on any matter in such manner as it thinks just and may take into account opinion, evidence, etc. But of course, it must give the parties an opportunity of adducing evidence in that regard. And then in section 10, at page 870, it says in section 10.2, the court shall make no order as to cost, that's the cost provision. Section 10.3, notwithstanding anything in this act or any other rule of law to the contrary, the court in the exercise of its power shall make such order or award in relation to a dispute before it as it considers fair and just, having regard to the interests of the persons immediately concerned and the community as a whole, and act in accordance with equity, good conscience, and substantial merits of the case, and so on. So effectively, it has a very broad discretion we're respectfully submitting, and there's no limitation on the exercise of its powers to a period of time before the close of evidence on the day that the trial begins. So we respectfully submit that the court did have the power to require the production of the transcripts and the audio recordings. Now, the court said that ultimately that the reason why they admitted the transcripts and or asked for the transcripts and the audio recordings was because the respondent had said that, first of all, parts of what he said had been taken out of context, and also that the appellant didn't take into account two pauses in what he had said in relation to the human resources manager. So the court thought, well, in order to resolve these matters raised, let us get the transcripts and the audio recordings so we can appreciate exactly what he was saying. And they did eventually ask for them a year and a bit and a few months later. And that is a source of complaint by the respondent. But in assessing whether the court acted fairly in asking for the transcripts and recording, if I may ask you to look first at electronic bundle, page 501, and this is in the cross-examination of the respondent before the industrial court. At the top of the page, the president of the court is asking counsel for the appellant.
I misheard you. Did you say page 541?
501, I'm sorry.
501, sorry.
Yes?
Yes. He says, the president said, Mr. Rudd, the point there would be that we can't believe him because he's hiding something. The respondent says, I don't have a recording, counsel, and you never had a recording? Yes, I have heard it, but I don't have it. And counsel says, okay, thank you, that's good enough. You said that you heard a recording, but you don't have it. So that the respondent is admitting in the court that in cross-examination, although he didn't have a recording, he had heard it. Now, in his memorandum that he filed in the reference, if you look at page 14 of the electronic bundle, he, first of all, in paragraph 11 of his memorandum, this is page 14 of the electronic bundle, he says, on the 16th and 20th November, the employee, while speaking on radio during the Big Issues talk show run by Observer Radio Antigua and Barbuda, made statements about aspects of the employer's operations. This he did in his capacity as chairman of LIAT and as such a trade union leader. So that there's no questioning in that paragraph of what he is alleged to have said. And then on the following page, 15 at paragraph 20, he says, the employee contends that his statements referred to in the dismissal letter and at paragraph 11 were made by him in his capacity as a trade union leader while the employee was off duty and off the job. So in that paragraph, he's accepting ownership of the statements that were quoted in the dismissal letter, and he is explaining why he, or at least the capacity in which he made those statements. So he's accepting that he made them. And of course, this is consistent with him already having heard the audio recording. He's accepting that, well, those are my words. And similarly, in his witness statement, which was filed later on, and you see that at page 22, he, first of all, in paragraph 13, Roman numeral 1, he accepts that he has made certain of the quoted statements. And then Roman numeral 2, he says, as to my remarks concerning Ms. Ramsey, the excerpt contained in the reference in the letter of dismissal does not reflect that there were two pauses. The first coming after the words Mrs. Ramsey doesn't, and the second coming after the words I don't believe. So we say again that again he accepts that the words fell from his mouth, as quoted in the letter, but he is saying that there were two pauses. And we say, of course, that is consistent with him having listened to the recordings, so that he's able to say, well, there were pauses. And then similarly on the following page, at page 23, paragraph 18, again maintains that his statements in the letter were made by him in his capacity as a trade union leader. Now, the request for the recordings was made by the Industrial Court on the 26th of January 2016, and the transcripts were supplied immediately by the appellant on the very same day, the 26th. On the 27th of January, at electronic bundle, page 231, the counsel for the respondent writes to the Industrial Court, and he says, prior to the court viewing, reviewing, or otherwise accepting the copy of the transcripts of the interviews referred to in the letter, our client would wish to have sight of same so that their authenticity and contents can be verified. Our client has never seen the actual transcripts, whether before or after his dismissal by the employer. Our client would therefore wish to be allowed to examine the same and to compare them with the actual recording before they are seen or considered by the court. And of course, that statement that you'd like to, no one has provided the actual recordings, but it's certainly consistent with his statement under cross-examination that he had heard the recordings before, so therefore he had access to them at some point in time. At that point, he doesn't ask for the recordings, so that the Industrial Court obviously assumed that he had the recordings, and this is why at page 232, they write, and they say, this is a letter of the 27th of January, they refer to the transcripts already received, and in paragraph 2, the court has no reason to doubt the authenticity of the transcripts. However, your client is at liberty to compare them with the actual recording and let the court have his objections and comments. So the court is inviting him at this stage, let's have your objections and comments on the transcripts and the recording. And then in paragraph 3 it says, in light of your letter, the President should be grateful to receive a copy of the actual recording, which you seem to suggest is in your client's possession. Then there is the letter of the 1st of February from the respondent's attorney. This is page 234, in which he says, in the third paragraph, he wishes to inform the court that he has never had or had access to the full audio recording of the observer interview. He's therefore not in a position to provide same to the court, because the court had asked him to provide the audio recording. And then he says the employer presumably had this and had accessed it, since it was the supposed contents of the interview formed the basis of his dismissal. So again, he's saying we don't have the full audio recording, which is also consistent with him having said that he had heard it. Maybe he had heard part of it, not the whole thing. And that is the assumption that the industrial court also made. So at paragraph 235, the court repeats at paragraph 3, I provide you the copy of the transcripts and invited him to let the court have his comments and objections, if any. And then it asks, I understand from your letter that your client doesn't have the full recording. Accordingly, I'm requesting that he provide the court with the part or so much of it that he has. So that is on the 3rd of February. There is no response to that letter by the respondent, and which causes the court to write on the 15th of June, some 4 months later, at page 679 of the record, of the electronic bundle, 679.
Yes?
Yes, which the court says, the President has directed me to refer to the correspondence passing between us and to inquire as to how soon I should expect to receive the part or parts of the audio recordings in your client's possession. I look forward to your prompt attention. And then on the following day, page 265, the respondent's attorney replies to say that please be advised that the employee has never had or been in possession of any part of or the entire audio recording, which I presume is, strictly speaking, accurate, or I presume that doesn't contradict his statement under cross-examination that he heard the audio recording, because I imagine it's possible to hear it without actually being in possession of it, but certainly he had access to it, having heard it, and therefore, essentially what I'm asking the court, the board to do is to assess the evidence on the premise that the respondent had already had access at some point in time to the audio recordings, had heard it, and therefore had previously had the opportunity to compare the audio recordings with what was alleged against him in the letter of dismissal. But in any event, the evidence is that the appellant provided the full transcript since the 26th of January, and later on provided the audio recordings, one in June and then the second in September. And you will see...
Mr. Mendes,
yes,
we've been looking at 265.
Yes.
We've been reading the employee's attorney's letter.
Yes.
Talking about a notice of objection relating to the admission into evidence or
yes.
consideration by the court of
yes.
the recording.
Yes.
Where do we find an explanation on behalf of the employee as to why he was objecting to that? What was wrong with the transcripts? To what extent did they depart from the recordings?
Well, he never says that.
He's never
He has never said that he's never said that the voice on the audio recordings is not his voice.
Well,
he's
that
never
might
said
not
that.
be the end of it.
He has never said that the transcripts themselves, which are before the board, are inaccurate, do not reflect the actual audio recordings. He's never made that claim at any point in time. He's had them, but he has never said to the industrial court, the transcripts are inaccurate, or look at this part of it, look at this what I said on this date. He hasn't said anything of this sort. He made the objection that he's referring to on June the 6th, 2016, basically saying that you ought not to receive it into evidence because the employer did not put a defense in and did not lead evidence of its own, and the industrial court was making the request for the transcripts a year and a bit after the trial had been closed. You'd see that in its objection on the 6th of June, which you will find. He is going to look to it for me very quickly so I can give you the electronic
number. Would it be
number.
238, Mr. Mendes?
Probably right, my lord. Yes, it is at 238. You will find the objection there. But in that objection, he's not complaining about the accuracy of the transcripts. He's just saying that he's saying rule on the employer's application to reopen the case first. But in any event, he's objecting to the fact that the industrial court is considering receiving it into evidence late. But at no point in time has he complained about the accuracy of the transcript or the audio recordings.
Very well.
And you will see on the 20th of September, this is at page 267 of the electronic bundle, his attorney writes to the registrar and he says, in the second, the reference and a subsequent application have been heard by the full court with judgment being reserved in both instances. The subsequent application is referring to is the appellant's application to reopen the case. And he says, we have sent several letters inquiring as to the likely date of the delivery decision. Our client is anxious to have this matter completed. We shall be grateful if we could be provided with an update. And on the 23rd, the court replies at page 268, second paragraph, you should recall that in an effort to fully inform itself of the pertinent matters, the court requested copies of audio recordings of November 6th and 20th. In that regard, partially disclosures made by the employer on June 20th. Fortunately, despite repeated requests, the recordings of November the 26th were not filed by the employer until September the 12th. So the court is basically explaining why it hasn't delivered decision yet. You should appreciate that the precise utterances of the employee and the context in which they are made are paramount for the just determination of the issues arising in the reference. Now that we are in possession of both recordings, the court will endeavor to advance the matter as soon, that should be as soon as practicable. So the court is signaling here the importance of these transcripts and the recordings, because they need to find out the context in which the respondent said what he said. He had himself raised the questions of context and the existence of these pauses. And they had previously asked him for his objections and comments on the transcripts and the recordings. And after this letter, he basically is silent. The next thing that he does is in March the 14th, 2007, page 270, is to ask again, as he is entitled to, of course, when is judgment going to be delivered? That is page 270, but nothing about the recordings and the transcripts. That's 270. And then the record indicates that he filed judicial review proceedings against the industrial court because of the delay in delivering judgment. And then the court soon thereafter delivered the judgment, and the judicial review proceedings were withdrawn.
So after he got the second recording,
yes,
how many months did he have in which he could have approached the industrial court? Look, I want to give further evidence about this, please.
So September 2016 is when he got the second recording, yes. And the judgment was delivered in July of 2017, as I recall. But in March of 2017, which is some 6 months later, he's asking for the judgment.
Very well.
So we say that that is the context in which the Court of Appeal ought to have assessed whether the decision to admit the transcripts and the recordings into evidence was procedurally unfair. We respectfully submit that he was heard on his objection to the admission of the transcripts and the recordings, because he put in a written submission, and the court answered it in its judgment. And also he was given the opportunity to make comments on the recordings and the transcripts. And certainly in the letter of the 23rd of September, the industrial court had indicated the importance to which it was attaching the recordings and the transcripts to understand precisely what it is that he said. And even after that letter of the 23rd of September, he does not address the court, even though invited to make comments, etc., does not address the court on the transcripts and the recordings. So we respectfully submit that the court did not deny him an opportunity to be heard, either on the question of admissibility or on the question of the contents of the transcripts and the record, and therefore they ought not. The Court of Appeal was wrong to reverse the court's decision on compensation, because that was the only basis upon which they did it. We therefore ask that you restore the decision of the industrial court on the assumption that you are not, with us on the first part of the appeal. We ask you to restore the judgment of the industrial court that the appellant only pay 35% of the compensation. Alternatively, if you are not with us on that point, we say that if you agree with my learned friend that the industrial court breached the principles of natural justice, then ordinarily the order that a court would make is to send it back so that they could comply with the principles of natural justice, so that they can give the respondent a proper opportunity, or the opportunity that he's claiming, to be heard on the recordings and the transcripts. What the Court of Appeal did was to send it back because they accepted that they could not assess compensation themselves. They sent it back, but with the stipulation that the industrial court was not to have regard to the transcripts and recordings. And we respectfully submit that that is a wrong direction, and that if you agree with the Court of Appeal on both aspects, then you ought to disagree with them on that aspect, at the very least, and don't inhibit the industrial court in that way.
Thank you very much indeed.
I hope I
well
was
done.
as brief as you
Well done.
expected.
Nothing was neglected, unless Mr. Ali has got some point that he'd like to follow on.
Mr. Ali only asked me to point out that the decision of the industrial court, the Court of Appeal of Trinidad and Tobago that I was referring to, the first decision was in the flavor right case, not in the All Trinidad case. I gave the wrong name.
Thank you very much indeed. Well, Mr. Ali, do you want to say anything else to us? All right, thank you very much indeed. Right, Mr. Ferguson.
Yes. Thank you, my lord. With your permission, my lord, I would wish to just emphasize a bit in relation to the factual matrix of this case. The appellant in this matter, and that's not in dispute, had an opportunity given on at least 4 occasions, as the record reflects, to present its memorandum of defense before the court. It did not do so. In fact, the record reflects that on November 21st, yes, 2014, 3 days before the trial of this matter, an application was made to put in a memorandum of defense, and that application was dismissed.
Yes.
Therefore, the result of all of this, having by its own inaction, failed or neglected to put in a defense, this matter proceeded with the evidence only of the respondent before the court.
Yes, well, that's all agreed.
Yes, right, that's agreed. And so as far as evidence is concerned before the court, the only evidence was the evidence of the respondent. And I emphasize this point, my lord, because the court ought to be guarded about the introduction of the appellant's case at this level, whether at the level of the Court of Appeal or this level, because many of the references of learned senior counsel point to evidence that was not before the court. For example, there was a parallel action before the High Court filed in 2012. The dismissal was on the 5th of December 2011. In June 2012, there was an action for wrongful dismissal before the High Court in which a defense was put in. But that action was discontinued. I see my friends in their submission refer to it as a pending action before the court. But that was discontinued in 2012.
Right.
They then in 2013 applied to dismiss the reference before the industrial court, but that was refused.
Right.
So, my lords, what we are left with before the court is the evidence of the respondent with respect to the material aspects of the allegation. In fact, what the only evidence was contained in the letter of dismissal, because the letter of dismissal stated why the appellant dismissed the respondent. One, for statements made on November 6, 2014 or 2011, which are referred to as the unqualified management statements, and on November 20th, which they referred to as the airline safety statements. With respect to the unqualified management statement, the answer of the respondent in the industrial court, which we submit respectfully, ought to be an answer to be accepted as is, because they did not have any evidence otherwise before that court, is that I did not say that Ms. Ramsey, who was the human resources manager, I did not say that she was an uneducated person. In fact, what I said was that she was an educated person. This was at the trial on November 14th, 2014.
Yes.
Right. So, one. And with respect to what my learned friends refer to as the airline safety remarks, he said, I never said that this airline was unsafe. I never said that. I am a trade union leader. In fact, I'm the president of the airline LIAT, which is the Leeward Islands Airline Pilots Association. And we were in the midst of industrial dispute.
He didn't say it was unsafe. He did say it was less safe than it had been.
Right, but he said that in context, lady, airlines. And may I, in fact, refer to the safety newsletter of the appellant, just to put all of this into context. And it's found in volume 1, the page. It's contained in pages 31 to, because I'm referring, my lords, to the last page. And this is coming from the appellant itself.
Yes?
On page 34, my lords, page 34, conclusions, under conclusions. And this is a document generated by the appellant.
Was it in the public domain, or was it confined to the LIAT company and the pilots and so forth?
It was the LIAT and the pilots.
So it's not in the public domain?
No, it was not a newsletter in the public domain. No, it was not. But I refer to conclusion number 1, my lords. It says the maintenance reliability of our aircraft is clearly not what it used to be and frequently challenges our crew and maintenance technicians. Now, it is not in dispute that this company, LIAT, has a great safety record. That is not in dispute. The pilots then were in the midst of an industrial dispute. This respondent, in his capacity as trade union leader, while at the material time being off the job, in an interview, and there is nothing abnormal about that, makes certain statements.
Well, if the statements are defamatory of the company, what matters it that he was making statements as a trade union representative and while off the job?
We have, it's our respectful view, Miller, that those statements were not defamatory.
Well, that's a different question.
Right.
But on the premise that they were defamatory, they're not robbed of that quality, are they? Because he is making the statements as a trade union representative, or because, to put it as you have done, he's off the job.
No, I am not. In fact, I am not saying, Miller, that because he was off the job and because he was a trade union leader, he can make any statement, whether defamatory or otherwise.
Well,
I'm saying...
What is the relevance of the circumstance that he was a trade union leader and that he was off the job? What does that bring to the debate?
Because the context, I'm saying the context within which he made the statements, and contrary to the conclusions arrived at and submissions made before you, my lords, that this respondent never said the airline was unsafe. And he was saying in the context, of what he saw as the management of LIAT, the increasing the number of managers, and in fact, may I just refer directly?
Well, before you do that, just to return to my Lord Wilson's question, you may be technically correct in submitting that he did not say that the airline was unsafe, but did he not say that since the departure of the two captains whose names I can't now recall, that it was less safe than before?
Right. He made the statements, and I would, just for ease of reference, he made the statements in answer to a question asked by the interviewer based on LIAT's safety record. And he made the statement in the context that LIAT has now increased its management, that's the appellant, to 65. And before, in the early days, there were only about 4 persons. And he's saying, increasing it by 65 does not make it less safe.
We have the interview at pages
Yes.
212 to 228. Could you just direct us to the particular passage in the interview you are now talking about?
And that's from the electronic bundle.
Yes.
Yes.
It's page 225. Thanks.
Yes. Right. Page 225, my lords. And we see the interviewer, Sheldon Daniel. We see the name Sheldon Daniel.
Well, I think we can concentrate on the answer. Let me put it to you as a professional pilot. I'm one of the most senior pilots in LIAT right now. LIAT right now is not as safe as it was when we had two managers. That's a pretty unambiguous statement, isn't it?
It says, and he's making that point in the context of what he refers to as 65 managers now. And the interviewer is asking the question in the context of justification for having 65 managers. And he's saying it is not as safe as when we had two managers. And I represent the training captains. He says the standards of operation and safety that we have now are not better. That's with the 65 persons. And if anything, are less than we had when Captain Murray and Captain Lake alone was running the flight operations.
Whatever the context, do those statements not partake of an allegation that LIAT is less safe at the time that this interview took place than it had been previously?
Millard, the taken in context, I would respectfully submit that the statements, even he says less safe on the face of it, and we have to accept that he said less safe, but they do not extend, this is our respectful submission, to being unsafe. Because, in fact, lower down he says that the pilots, as we contend in our legal submissions, the pilots are well trained. He says so. The pilots of LIAT are well trained, and they are the ones who fly the airplanes. He was dealing specifically, Millards, with what he referred to as a confrontational group within the appellant's organization, and even not the appellant itself. And maybe, Millards, we can take it. May I invite Millards to the appellant's reply, where they have emphasized the particular statements that, if I am permitted to, that I can highlight. It's in the appellant's reply, and page 3, starting from page 3.
Thank you. Yes.
Right. And paragraph 5 on page 3, Millards. Says, LIAT is now telling me that they have increased the amount of staff under Mr. Challenger to the extent that the managers now total over 55. And they include such posts as manager of catering, where LIAT has no catering. There has been industrial conflict with my association because they are going to even serve water on the flights, and you have a manager collecting all the monies. The context in which he was saying this is that the entity was looking to dismiss pilots, the pilots who are the trained persons who fly the aircraft, and at the same time they were increasing the numbers on the management team. So essentially that is what he was saying and the context within which the remarks were made.
Can you, so that I can focus on these submissions, help me as to what issue it goes to, these submissions about
Because
conduct?
the conclusion of my friends is in relation to the remarks about safety, that basically what he was saying is that the airline is unsafe.
Yes, but can I just be, perhaps I haven't made my question clear. The issues before us are the legal test on fair dismissal, the power of the industrial court of its own motion to get the transcripts, whether he was denied a right to be heard on those transcripts, and whether the industrial court should have been precluded from looking at them when the matter was remitted.
Yes, my lady.
Those are the issues. Which of these issues did these submissions go to?
Right. In fact, they go to the transcripts. The transcripts are the issue of the transcripts. And in fact, that's why I contextualize what we saw as some of the key facts in this issue. So, my lady, what I'm saying, in effect, is that at the trial, LIAT led no evidence. They had the burden of proving that the employee respondent was fairly dismissed. The burden rests on them to prove that the employee was fairly dismissed.
Well, I think we've established that a number of times already, Mr. Ferguson. It is clear that the appellant was, to put it as benevolently as one can, deficient in its prosecution of its defence, and it was debarred from adducing evidence. But as we have heard, it was permitted to make submissions to the industrial court. The argument against you is that the industrial court, in order to equip itself with sufficient evidence to make a judgment on various areas of dispute, was perfectly well entitled to solicit the transcripts of the evidence. And indeed, it alerted your client to the circumstance that that was being done. Now we have the transcripts, and I don't understand you to say that the industrial court was not entitled to have regard to those. But if you are saying that, then I think we might have articulated the submission in support of that contention. But if you're not saying it, then my lady's question is, if I may say so, entirely pertinent. What is the point that you're trying to make in relation to the import of the transcript? Because as I've been trying to point out to you, certainly at first blush, they appear to suggest that the safety standards of LIAT were not what they used to be. So those are two questions. First of all, do you say that the tribunal was not entitled to obtain the transcript at all? Is that
Yes.
Yes.
In all the circumstances of this case, our submission is that they were not entitled to, first of all, request the transcript. That's our first submission.
Yes.
They were not entitled to request the transcript. And may I refer...
Well, can you say in a sentence why you say they were not entitled to request the transcript?
Because, my lord, and may I refer you to section 9
Yes?
of the Industrial Court Act, and it's found in paragraph 4 of the Joint Bundle of Authorities.
Yes?
And 9 says, in the hearing and determination
Sorry,
of any
just give me a
matter,
moment, please.
Sorry.
What page is that, please?
sorry, page 869,
86.
paragraph 9 of the
Thank you very much.
Industrial Court Act.
Yes?
And it says, in the hearing and determination of any matter before it, the court may act without regard to technicalities and legal form, and shall not be bound to follow the rules of evidence stipulated in the Evidence Act. But the court may inform itself on any matter in such manner as it thinks just, and may take into account opinion evidence and such facts as it considers relevant and material. But in any such case, the parties to the proceeding shall be given the opportunity, if they so desire, of adducing evidence in regard thereto.
Right.
So our submissions are twofold. One, the case having been closed on November 24th, 2014.
Yes?
There, evidence received, case closed. On January 15th, there was the hearing of an application by the appellant to reopen the case.
Yes, well, we know all of that. We know all of that.
Right.
But are you saying that Section 9 precludes the court, after the case is closed, from seeking further material that might affect its determination?
I am not saying generally, I'm saying in the circumstances of this case, they would have been precluded, certainly at the time that this request was made.
Well, what were those particular circumstances which disapplied Section 9?
One, Milan, is that on January 15th, 2015, at the end of the hearing of the application, there was the outstanding judgment or decision with respect to the substantive hearing on November 24th, and that hearing would have determined whether or not the case was reopened.
I see.
That application, no judgment was ever given with respect to that application on January 15th, 2015. The industrial court never gave any judgment. So what that application would have done, if they decided to reopen the case, then they would have set a date for the trial to continue or for LIAT to put in evidence.
Right. Well, I think I understand now why you say Section 9 doesn't apply.
Right. And if they decided to dismiss LIAT's application, the only issue would have been the decision with respect to the substantive trial on November 24th.
Yes?
So, what happened thereafter, That's why I say the factual matrix is important. In June 2016,
Yes?
the respondent writes to the industrial court asking about the judgment.
Yes, quite. Well, we've heard all of this already, Mr. Ferguson.
No, I'm dealing with 2016.
All right.
No,
All right.
2016. Between, as the record will reflect, because we are waiting, my lords, on the decision with respect to the interim application.
Yes.
And the June 2016 letter, which I will get a copy, my friend is just locating it in the bundle.
Yes?
It's saying, we have, kindly can you let us know what is the decision with respect to the interim application? The response comes in August that the judgment will be delivered by the end of September 2016.
Yes.
So there is an expectation of the respondent and his team that we are waiting, that we'll get the judgment at the end of September. There is no correspondence from the industrial court between September, when the judgment was to be delivered, and January 2017, which prompted the attorneys on behalf of the respondent to write to the court asking when would the judgment be delivered.
Yes.
And they responded, judgment would be delivered, my lords, on January 29th. There is no issue at all about transcripts at that time. This is now 1 year later, after the interim application is made.
Yes?
Mr. Ferguson, one of the points made against you is that by September 2016, you had, first of all, the 2 transcripts, and second, the audio recordings referable thereto. So you had all the material by September 16. We know that very belatedly, the industrial court did not deliver its judgment until the 13th of June, 9 months later. And the point that you might like to deal with sooner rather than later is, why did you never apply to the court, write to the court, issue an application before the court between September and June saying, now we've got the recordings, now we've got the transcripts, we want, please, to make submissions. We might even want to recall our client if the industrial court were kindly to allow us to do so.
It is our submission, my lord, that we did so.
Ah.
And may I refer the court to the electronic bundle the page number 238.
Yes?
And this is a notice of objection to admission of transcript.
Yes,
I think I'm talking about the period between September 2016 and June 2017. You're referring us to a document dated June 2016.
June 7th, yes. And what I'm saying...
Please focus on the period to which I was addressing.
September. Our expectation, my lord, based on this objection that was filed on June 7, 2016, our expectation was that the industrial court, if they intended to pursue the transcript, will afford the respondent an opportunity to make submissions with respect to the transcript. That is what our expectation was. And why I believe, my lord, that the notice of objection is important is that it says specifically, and may I refer to electronic bundle, page 239, paragraph 5.
Yes?
Under the grounds of objection, it says, by letter dated January 26, 2016, the court requested the attorneys for the employer a copy of the transcript of the interviews held on November 6th and 20th, 2011. The employee has queried the authenticity of the transcript, particularly in the absence of the audio recordings from which the transcript has supposedly been made. The court has requested the audio recording from the employers. And then it goes on at 6. Because this is June 2016, and said since then, those audio recordings have not been produced. And in any event, it goes on, the second sentence, paragraph 6, that the employee contends that the production of the transcript bears no relevance to the decision to be delivered by the court as to whether to grant the employer's application for an extension of time. The employee has been awaiting that decision for the past 16 months. So, right or wrong, the respondent's position is that he's objecting to those transcripts. And he says so in very clear terms. And he goes on to say that makes mention of the indications given by the court to hand down the decision. And he goes on to say at 10, electronic bundle 240, as a matter of law, the employee ought not to be obliged to produce at this stage any document upon which there is no opportunity to cross-examine or be cross-examined. In any event, the employee was already cross-examined extensively by the legal representative of the employer at the November 24th hearing. The said interviews, the transcript for which is now being introduced, had supposedly formed the basis of the employer's decision to dismiss the employee. Notwithstanding that, the employer has failed to submit the transcript or any part of it at the hearing on November 24th. Put simply, my lords, the respondent's position is that what the industrial court was actually doing, despite dismissing on several occasions, on the 21st of November, dismissing the application to put in a memorandum of defense, was actually taken through the back door what the appellant, as part of its duty to prove its case, its duty in law to prove its case, ought to have been doing through the front door. It is the appellant who did not, on its own volition, choose to put any evidence before the court. So our objection says, one, we object to the transcript going in as part of our grounds of objection. One, and two, if it goes in, then the respondent at least should be allowed an opportunity to cross-examine and be cross-examined on it. That is what we are saying.
Could you just remind me which paragraph that was?
That's paragraph 10.
Right, thank you.
Right, so what we expected, having put in a formal notice of objection in this case, that we would be heard on what we describe as a matter of law about the entry of the transcripts at that point in time. And two, if the court disagrees with us, then they must allow us to cross-examine and be cross-examined on the transcript. Because clearly, these are transcripts being produced 5 years after the statements are made. The employee says, I am not in possession of the audio recordings. The appellant is asked to produce the audio recordings. And just by way of example, if I may be permitted, my lords, this appellant says, I never said what you allege that I said in relation to Ms. Ramsey. You say I said she was an uneducated person. I say I said she was an educated person. No, that is an issue of conflict. If the industrial court, the position of the industrial court is to introduce the evidence of the transcript, then he must be allowed to say, listen, it may be this is not my voice. It may be this is an edited version of the transcript.
But, Mr. Ferguson, he got the transcript and he got the audio recordings. I mean, he must have known whether it was his voice or not.
Yeah, but I have given it by way of example, my lord. But I'm saying even though the industrial court has a power to request the transcript, and I'm not saying simpliciter, that power does not exist. But the power is qualified in section 9 itself, and that's what I'm saying, that he shall be given the opportunity if he so desires. This is what 9 says. He shall be given the opportunity, if he so desires, of adducing evidence in regard thereto. So the transcript itself formed a critical part of this case. He was brought into court in an entire trial on November 24th, 2014, and no transcript, no part of a transcript was put to him. The trial was completed.
Yeah, I think we've probably got that the trial was concluded, yes.
Yes, so I'm saying in that context, and certainly we are saying if my lords disagree with us, that the court had the power to request the transcripts as they did, certainly the inordinate delay in requesting the transcripts ought to be a factor to be taken into consideration. That it would have amounted to a wrong exercise of the court's discretion.
It's really Alice in Wonderland, this, isn't it? When you think, 24th of November, 2014, Captain Blackburn goes into the witness box and he says, the way this has come out is quite wrong. There were 2 pauses there. End of hearing. The industrial court goes away, thinks about it for a long time, too long probably, thinks, in fairness to the captain, I think we ought to have the transcripts, because he said there were 2 pauses, which means that, as presented, this is entirely unfair. So in fairness to the captain, we better call for these. And now, You said to the industrial court, you can't have the transcript. You made that point in the Court of Appeal. Here you are, before the Judicial Committee, saying it was quite wrong to call for the transcripts. It's ridiculous, Mr. Ferguson, with all due respect, isn't it?
Well, I'm saying in the context of this case...
That's what I'm talking about, too. Right. I'm talking about the context of this case.
May I refer you to Section 16?
Certainly.
Of the Act? It's on page 874 of the bundle. 874.
Yes.
The court shall expeditiously hear, inquire into, and investigate every dispute, and all matters affecting the merits of such dispute before it, and without limiting the generality of the foregoing, shall in particular hear, receive, and consider submissions. The law requires that the court shall expeditiously hear matters. Section 16 of the Act.
Yes.
Section 9 says, if it is my Lord's view that you can request the transcripts, for example, in this case. All we are saying, my Lord, and that's the point, the underlying point that we are making, is that having filed a notice of objection, whether the court agrees or disagrees with us, we ought to be afforded the opportunity to be heard on it.
Right.
And it is that expectation that we had, that the court, if it's decided to reopen the case, of course, it will hear us, or it might afford us the opportunity to appeal on that point. Because the decision with respect to the application made by LIAT is only given with the rest of the judgment. It was contained in the judgment delivered in June 2017. Right? June 2017. So that's the main point. We're saying if the court had the power to admit the transcript, then it waited so inordinately long to request those transcripts that it would have been an arbitrary exercise of its discretion in those circumstances, given that it has a statutory duty to expeditiously hear and determine matters. And so that's one limb of it. But even if the court disagrees with us, all we are saying is that we were entitled to a hearing with respect to our notice of objection on June 7th, 2016. June 7th, 2016 is the date of our notice of objection. And certainly, had we been heard, then the court was at liberty to disagree with us and rule against us and move on. But having not given us an opportunity to be heard in relation to the transcripts, which form the central part of the court's decision to award the 65-35 ratio in damages. And may I refer Ballots to the Industrial Court's decision, paragraph 111.
Yes.
Of the Industrial Court's decision.
Yes.
In which it has explicitly indicated, leaving no room for doubt, the basis upon which it has reduced the compensation by 65%. And that, my lords, is to be found in the electronic bundle, page 163, paragraph 111.
Thank you.
Yes. With your permission, it says, at the end of the day, we find that on the evidence disclosed in the transcripts and audio recordings, subject to the proper administration of the established fair procedure, the employee was guilty of misconduct, which was serious enough to potentially justify his dismissal.
Yes.
So, in effect, what members of the Industrial Court did was to quietly sit in a room, listen to the audio recordings, read the transcript without any reference whatsoever to the respondent, and come to a conclusion as significant as what is contained in 111. We shall reduce your damages by 65%. And in the authorities produced by my learned friend out of Trinidad, the Caroni case, and I don't think that is in dispute, where Chief Justice de la Bastide said that you can challenge based on process, natural justice principles, but you can challenge the decision if it is in breach of natural justice, as we respectfully submit, that they were in breach of natural justice principles by not giving the respondent an opportunity. And if my lords were to agree with my learned friend that he got an opportunity because he received it and he was asked to comment on it, then certainly, in our respectful view, that would not be an adequate opportunity in the context of his expression of his desire pursuant to Section 9 by filing a notice of objection on June 7th, 2016.
Yes.
So that is basically our submissions with respect to the transcript, because our sole ground of appeal with respect to, in the Court of Appeal, had to do with the reduction in compensation by 65%. And as the Court of Appeal accepted, based on Section 111, we don't have to speculate as to why the court reduced the compensation. It did it based on the contents of the transcript.
I have just one question arising out of your submissions. You made the point to us that the Industrial Court never gave a decision, a discrete and separate decision, on the application to reopen, which was made in January 2015.
Yes, my lord.
Part of the application to reopen was on the premise that the employer wanted to put in the transcripts. Obviously, the employer was seeking more than that. They wanted a full hearing. Was it not apparent by 2016 that whether or not the application to reopen was going to succeed in full, at least as a halfway house, the tribunal had made a firm decision to receive the transcripts.
By 2016?
Yes.
Yes, my lord. By January 2016?
Yes. So having got that far, you could then have written to the tribunal and said, well, look at section 9, now set up a hearing for us to give evidence or make submissions.
What we are saying, my lord, is that the effect of the notice of objection filed on June 7th is exactly that. That if the court is requesting the transcript and we are saying that we object to it as a matter of law, but if you are going to admit those transcripts, then we wish to have an opportunity to cross-examine and be cross-examined on it.
I asked you which paragraph of the notice of objection. You said paragraph 10.
Yes,
but
paragraph
that's
10.
Not actually clear to me from paragraph 10. It seems to read as an objection,
Yes.
rather than an invitation to set up a hearing.
Yeah, I'm just getting the
E238, somewhere around there, I think.
Page 240, you want?
yes. It says, as a matter of law, the employee ought not to be obliged to produce at this stage any document upon which there is no opportunity to cross-examine or be cross-examined. I will answer it this way, my lady, by saying that what was clear from the face of the document is that the respondent was objecting to the transcripts going in. And by saying, in paragraph 10, as a matter of law, the employee, who is the respondent, ought not to be obliged to produce at this stage any document upon which there is no opportunity to cross-examine or be cross-examined, they read together with paragraphs 5 and 6. Which says, paragraph 6 says, the employee contends that the production of the transcript bears no relevance to the decision to deliver by the court as to whether to grant the employer's application, etc. So having done that, and in paragraph 6 and paragraph 5 says, the employee has queried the authenticity of the transcript, particularly in the absence of the audio recordings from which the transcript has supposedly been made. So it is the appellant's representative, Desmond Brown, as is accepted in this case. He prepared the transcripts. He prepared the transcripts from audio recordings, no doubt sought and obtained by the appellant. So this is a situation in which even there was no independent chain of custody for those documents. It is produced by one side, and the one side that produces the document is those who have dismissed the respondent and who contend that he was fairly dismissed. So all that the respondent is saying is that we object, we don't think it bears any relevance as a matter of law, and we think if you are introducing it, then he ought to be allowed to cross-examine or be cross-examined on it.
Yes.
Right. So this is the position. We are not saying, and we are not so presumptuous, my lord, to say that the court would have agreed with us. The court may have disagreed.
Of course.
And but all we are saying is that we were entitled to an opportunity to be heard. That's all.
Yes. Thank you very much.
Yes. So if there is, can I move on to the unfair dismissal? If there are no questions regarding the transcripts? Yes.
Thank you very much.
Yes. Now, with regard to the unfair dismissal point, my lord, the court has relied, the appellant has relied on primarily the English cases with regard to unfair dismissal. We submit first and foremost that there is a distinction in the UK provisions, the UK Protection of Employment Act, 1978, later becoming the Employment Rights Act, 1996. And may I invite my lords to section 57(3).
Yes.
Of that act, and it's contained in tab 4. Yes, I have it. Yes, it's page 877 of the bundle.
877. Thank you very much.
Yes, 877 of the bundle. And
So wasn't
says-
this bit included in the 1996 Act?
yes, my lord.
It was.
Yes,
Okay.
It basically says the same.
The same, okay.
The thing.
Okay.
There is no fundamental difference between the 1978 and the 1998 Acts. It says where the employer has fulfilled the requirements, and that's electronic bundle 877, where the employer has fulfilled the requirements of subsection 1, then subject to sections 58 to 62. And we did, the extract does not contain the sections 58 to 62, but we have photocopied them to be made available to the court, but they're not relevant with respect. They deal with pregnancy, redundancy, and so. But for completeness, we have copied it and supplied to the other side.
Thank you very much for that. But if they're not relevant, let's not be distracted by them.
The determination of the question, whether the dismissal was fair or unfair, having regard to the reasons shown by the employer, shall depend on whether the employer can satisfy the tribunal that in the circumstances, having regard to equity and the substantial merits of the case, he acted reasonably in treating it as a sufficient reason for dismissing the employee. So under 57(3), the court takes into account the equity and substantial merits of the case. In fact, section 98 he essentially says the same thing, it's just structured a bit differently. 98.4. This is to be found in 98.4, and that is at page 881 of the bundle. And it says, depends upon whether in the circumstances, including the size and administrative resources of the employer's undertaking, the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee. And it shall be determined in accordance with equity and the substantial merits of the case. If I may compare and contrast with the Antigua and Barbuda test for unfair dismissal, and it's contained in section C58(2) of the Antigua and Barbuda Labor Code, my lords, and that is to be found on page 852 of the electronic bundle, and the relevant extract is contained on page 17 in the case for the respondent, electronic bundle 781, page 781. But it says, the test generally for deciding whether or not a dismissal was unfair is whether or not, under the circumstances, the employer acted unreasonably or reasonably. But even though he acted reasonably, if he is mistaken as to the factual basis for the dismissal, the reasonableness of the dismissal shall be no defense. And the test shall be whether the actual circumstances which existed, if known to the employer, would have reasonably led to the employee's dismissal.
Yes.
And the Trinidad and Tobago legislation that was already mentioned by my learned friend, he mentioned section 18 of the legislation and 10.6 in particular. And if I may, just to make a distinction, the relevant legislation, unlike the UK, is not to be found solely in the Antigua and Barbuda Labor Code. It is to be read in conjunction, we respectfully submit, with the Industrial Court Act. And in particular, with section 10.3 of the Industrial Court Act. And section 10.3 speaks to, and that is to be found on page 870 of the electronic bundle, 870.
Yes.
It says 3B in particular, act in accordance with equity, good conscience, and the substantial merits of the case before it, having regard to the principles and practices of good industrial relations, and in particular, the Antigua and Barbuda Labor Code. So, apart from equity and substantial merits in the UK legislation, it's 870.
Yes.
I've got it. I'm just comparing the statutes.
Yes. Apart from similarities, whether or not the employer acted reasonably, one, you have regard to equity and you have regard to the substantial merits of the case. In Antigua, it goes further, we respectfully submit, and it speaks to, in the Industrial Code Act, good conscience, and having regard to the principles and practices of good industrial relations, in particular in Antigua and Barbuda. In other words, you take into consideration the local circumstances as exist on the ground. That's in Antigua and Barbuda. And further, there is a qualification contained in section 58 to 59 of the Antigua and Barbuda Labor Code, section 59, immediately following. Section 59, that speaks to, and let me just get the exact page on the electronic bundle, 852.
Sorry, what's the page?
That's 59.
Yes, that page?
Section, page, sorry, 852.
852, thank you.
Yes, 852.
Yes?
Yes. And 59, 1 says, an employee may terminate the employment of an employee where the employee has been guilty of misconduct in or in relation to his employment so serious that the employer cannot reasonably be expected to take any course other than termination. Such misconduct includes but is not limited to, and it gives the situations here. A says, conducted himself in such a manner as to clearly demonstrate that the employment relationship cannot reasonably be expected to continue. And you have 2. Where an employee is guilty of misconduct in or in relation to his employment that is not sufficiently serious to permit his employer to terminate his employment under subsection 1, but is such that the employer cannot reasonably be expected to tolerate a repetition, the employer may give the employee a written warning which shall describe the misconduct in respect of which the warning is given and state the action the employer intends to take in the event of repetition.
Well, is that an issue in this case? Is that relevant to this case?
It is only relevant, my lord, to the extent that if there is misconduct, dismissal is not the only the only option that the employer faces.
Okay.
I was going to make a rather more pedantic point, which is that if it is relevant, it's actually been repealed and replaced by another provision which is similar at 859 to 860, but I haven't worked out what the differences are.
859, Lord?
Yes. I mean, I don't know if it matters, but if you are placing reliance on 2, 2 has been repealed and replaced by what we see starting at the bottom of page 859.
Well, the substance of it is the same,
Right.
Millard, which is there is an alternative in the context of misconduct to there's an alternative of a written warning.
But it's not being argued, as I understand it, it's not being argued that the employer should have had resort to that in this case. Is it? Or is it?
Well, in the circumstances, what we are submitting is that summary dismissal for a respondent who has served a company for 33 and a half years in the context of this case.
I'd like to appreciate all of that. We've got that very, very clear indeed, Mr. Ferguson. But is it being argued that in this case the employer should have had resort to the provision which allowed it to give your client a warning?
Our submission is that the employer had that alternative and in the circumstances of this case ought to have exercised that alternative as a lesser penalty.
I see, thank you.
That submission is not open to you. The industrial court found that what your client said on the radio on those two occasions was so serious and such a breach of the mutual covenant for trust and confidence between employer and employee that it merited summary dismissal. And the only reason why it found that the dismissal was unfair was the failure to give your client an opportunity to comment before the dismissal was actually communicated or decided. In those circumstances, and you did not appeal against that, you appealed against the 65% reduction. In those circumstances, it is not open to you, is it, to say that your client should have been given only a warning and not dismissed?
Brothers, if I may answer it this way, that the finding of the industrial court was unfair dismissal. We did not appeal against that. What we appealed against, because they found in favor of the respondent, they said they concluded that he was unfairly dismissed. What we appealed against was the reduction, which is the 65-35, which was based entirely, as the court said at paragraph 111 of the judgment, that it was based on the transcripts. That was the thrust of our appeal. We merely raised that point in the context that in the Antigua and Barbuda legislation, the penalty for misconduct is not solely dismissal. What the industrial court found is that it could have potentially justified his dismissal. Said he was guilty of misconduct that potentially could have justified his dismissal. But taken the entire case as a whole, it found that because of the several other breaches, including the fact that the employer gave no evidence in the court at the trial, that it amounted to an unfair dismissal.
I wonder whether, I don't expect you'll have a chance to answer this right now because of the time, but it might be thought that the case comes down in the end to a relatively discrete issue. The Court of Appeals said that they reminded themselves that the Industrial Tribunal wasn't to substitute its own decision for that of the employer when looking at reasonableness. Yes. I think it's being argued that that's, however, precisely what the Industrial Court did do. It made its own decision on what was reasonable rather than looking at what was within the band of reasonable decisions. And certainly what would help me is to have that point addressed at some point.
Yes, certainly I will address.
Would now be a convenient time, Mr. Ferguson?
Sure,
Yes, we will sit again at 2 o'clock. What's now adjourned.